voluntarily apply the common rule to all research conducted at their institution. However, not all research institutions adopt this policy, and in any case, if any improper research is discovered at these institutions, there are very few steps available to the federal government to do much about it. That says a lot. Third, a private institutional researcher who conducts non-federally funded research or is not seeking approval of the drug or device with the FDA does not have to apply the principles of the common rule to its research. In other words, there is a huge area of all the private medical research out there that is not under the common rule unless they choose themselves to voluntarily do it. That means they can take you or anybody that you know, and if they feel like it, they can drop you right into right on an operating table and operate on you against your will, and they can perform any type of thing they want to you. Because why? There is no law, there is no organization, there is no law enforcement that is willing to do any kind of investigation to help, and there's no one else out there who is going to, leaving that person a victim to these criminals. Fourth, no other agency other than HHS has applied the additional protections described in 45 CFR 46 for vulnerable populations, pregnant women and their fetuses, children, prisoners to their own research. So the purpose of this legislation is to help close the gaps that exist with the current system for protecting research subjects. Well, is there really a problem out there? Is this just a paper loophole that I am trying to close? Unfortunately, Mr. President, there are ongoing problems with inappropriate, ethically suspect research on human subjects. It is difficult to know the extent of such problems because the information not collected in any formal manner on human research. The Cleveland Plain dealer in my home state of Ohio has recently reported in a whole series of articles after much investigation of this issue, and I quote from him, "What the government lacks in hard data about humans, it more than makes up for with volumes of statistics about laboratory animals. Wonder how many guinea pigs we used in U.S. research? The Agriculture Department knows 333,379,000. How many hamsters in Ohio? 2,782. So we have all this data on animals and little on human beings. I would hasten to add that the guinea pigs the plain dealer refers to are four-legged kind too, and not the guinea pigs that are human beings used for research. The reason we know so much about the use of animals in research is that we have laws for the handling and treatment of them. For example, the Animal Welfare Act requires that certain minimum standards be maintained when using animals in research. Let me give you some recent examples which indicate why. Notwithstanding the common rule and the other protections that are in place, I think additional protections are needed in statute. In 1994 and 1995, in an effort to explore the rights and interests of people currently involved in radiation research conducted or sponsored by the federal government, the Presidential Advisory Committee on Human Radiation Experiments conducted an in-depth review of 125 research projects funded by HHS, DOE, DOD, VA, and NASA, according to the ACHRE report. Our review suggests that there are significant deficiencies in some aspects of the current system for the protection of human subjects. The ACHRE found that documents provided to IRBs often did not contain enough information about topics that are central to the ethics of research involving human subjects. In some cases, the committee found it was difficult to assess the scientific merit of a protocol based on the documentation provided. ACHRE's report states that some consent forms studied by the committee are, and I quote, flawed in morally significant respects, not merely because they are difficult to read, but because they are uninformative or even misleading. The report states further, our review also raises serious concerns about some research involving children and adults with questionable decision-making capacity. And the ACHRE concludes, all told, the documents of almost half of the studies reviewed by the committee that involve greater than minimal risk to the subject raise serious or moderate concerns. That is a horrible indictment. As I mentioned earlier, from December 15th to 18th, 1996, the Cleveland Plain Dealer published a series of articles entitled, Drug Trials, Do People Know the Truth About Experiments? And I want to give credit to people that worked on that. Keith Epstein has covered Capitol Hill here and has written much and done much investigative reporting working on this, as did Mr. Sloat. Bill Sloat, those two fellows worked on this and did a great job in pointing out some of the problems that still exist, and we have talked to them about some of these things. The Plain Dealer uncovered a number of disturbing cases, very disturbing cases as a matter of fact, where people were either unaware of the fact that they were involved in research or were not provided full information about potential side effects of research. The series raises very serious questions about the adequacy of our current system of protecting human research subjects. The Plain Dealer found, for example, 4,154 FDA inspections of researchers testing new drugs on people since 1977. More than half the researchers were cited by FDA inspectors for failing to clearly disclose the experimental nature of their work. Another serious finding in this series is that researchers who received the most severe penalty by the FDA, being designated disqualified investigators, have little fear of this fact being found out by their peers or patients. One of the articles discusses potentially serious problems in the way research conducted outside the United States is incorporated into applications for drug approvals in the United States. The Plain Dealer uncovered much evidence to suggest that the federal government continues to sponsor research where informed consent is not obtained, and this fact disturbed me greatly also. On November 14th, 1996, the Wall Street Journal published an article that examined the practice at one pharmaceutical firm, Eli Lilly and Company, in using homeless alcoholics in their clinical trials. The article raises some disturbing questions about the quality of the Phase 1 trials conducted by this one company. Also, serious ethical questions are raised concerning the appropriateness of paying homeless alcoholics significant sums to be research human guinea pigs. It is not clear from the article whether these tests were reviewed by any IRB. On December 27, 1996, the New York Times reported on a New York State appeals court ruling which found that the state's rules governing psychiatric experiments on children and the mentally ill were unconstitutional. The court found that the rules did not adequately protect people who, because of age or illness, cannot give informed consent to take part in drug tests or any other experiments. The article mentions 10 to 15 of the 400 psychiatric experiments covered by the ruling as being privately financed and therefore outside the coverage of federal rules. How would you like it if your father, mother, son, or daughter, husband, wife was in one of those institutions and was having experiments conducted on them without your knowing it and without them knowing about it? That is what we are up against. On August 15, 1994, the New York Times reported an ethical and legal questions regarding a company's efforts to promote a drug that can make some children grow taller than they otherwise would. The drug in question, proptopropin, has been approved by FDA for use in children whose bodies do not make sufficient quantities of human growth hormone. However, once approved, doctors may prescribe it for other purposes at their discretion. In this case, the company was apparently surveying schools for short children and then trying to funnel those children to doctors who would prescribe the drug, whether or not the children lacked the human growth hormone. This unapproved research was occurring without the oversight of an IRB, and at least 15,000 children have taken this drug. Get a load of this. They're going to give it to you. They're going to experiment on you, and they're going to definitely take your life and do whatever the hell they want to you. And there's no law in place to this day, folks, to this day, because this bill that Senator John Glenn tried to pass was